seller, because this is the roadmap of what you need to get to closing and what affects your closing. And so, our goal, I would say, is not to make you guys a title expert by any stretch of the imagination. You don't need any more burdens than you already have. But my recommendation is you just be familiar with how to read this title commitment so that you know when to begin asking questions either of the title agent, or if there's an attorney, of the attorney, or if there isn't an attorney, at least know when, hey, I think I better get an attorney in this right now. Okay.
Can I ask a question of the group? So I'm also very technically challenged, and I got the thing in the chat, but I'm afraid if I click on that, then I'm going to lose the meeting. So that's why I'm on here twice, because with my iPad, I also opened it up so I can be looking on that, but I don't see how on my iPad to find that thing. Does anybody know?
Yeah, I mean, if you look in where it says chat, Jamie was good enough to put a link directly in there. And if you click that link, it should open for you. Okay. Okay.
It didn't say chat. It just had 3 dots, but I clicked the dots and then it got chat.
Great.
Thank you. Sorry.
No problem. Okay, so let's start by looking at this. I know you guys, regardless of which side you're on, you get a copy of this in every transaction you do, regardless of what title agent you're working with. Most agents that I talk to say, yeah, I get it, and I stick it in my file, which is fine. But again, you can really save yourselves grief and anguish. I get calls from agents often saying, we're supposed to close tomorrow, and I just found out, fill in the blank. And in reality, they didn't just find out, but maybe didn't know how to read the title commitment, and therefore, if they knew and had read it, they would have realized that information was made available weeks ago. I'll also preface all this by saying, if you are representing a buyer and there's no attorney involved, typically the attorney is going to want to order title. But regardless, if there's no attorney involved, you're going, in my opinion, to want to order title as soon as you get out of attorney review. And the reason for that is, it doesn't happen often, but sometimes we have major title issues that you don't want to find out about 2 days before closing. I just completed a transaction in Ocean City. It was a $3 million transaction, and title was made available at 5:03 p.m. the night before a 9 a.m. closing, and there was a major problem that almost blew up the entire deal. So you want to order it as soon as possible. And be able to review it and know what you're looking at, okay? And so let's begin. Does everybody see on page 1 where it says WFG, National Title Insurance Company, Commitment for Title Insurance, Schedule A? That's what I'm looking at right now. So understand that when you deal with YHT or whatever title agent you're dealing with, they are an agent. They are not the one providing the insurance. So YHT and other title agents, when you give them a title order, has the searches completed, and the title examiner, typically it's Heather Andrea, who is fantastic at what she does. I can tell you, I use her as a resource when I have title questions. She looks at everything. She examines the title. And then based on the examination, this commitment is sent out. And so WFG, National Title Insurance Company, is the title insurer. That's who the actual insurance will be with. YHT is the agent that places it with them. There's only a handful of title insurers left in the United States. So it goes to them. Schedule A, we really are looking at 3 critical areas: Schedule A, Schedule B1, and Schedule B2, and that's what we're going to cover now. So Schedule A is what I call, who are we And what are we talking about? So it shows you the commitment date in number one. In number two, it shows you two things. Most of the deals we do have a mortgage. If there's no mortgage, there won't be a section B under number two, it'll just be an A. But it shows us that they're going to issue two policies. One for the purchaser of the property, and that's the insurance will be to the extent of the sale price of the property. So you see, this is a $475,000 purchase. And the second policy is simultaneously issuing a policy to the lender who's writing the mortgage to the extent of the mortgage. So here's what you want to be looking at here, regardless of which side you have. Is the sale price correct? And is the loan amount, does it match the amount in the contract? If your contract, if this is a $475,000 deal, and your contract says that the buyer is going to get a $100,000 mortgage, and you suddenly see that it says 250, as a buyer's agent, that's a cue to you to pick up the phone and call the other side and find out why that loan amount went up. Okay? That could be the signal of potentially of an issue or a problem, whatever. Nobody cares if it goes down because that's easier to get a mortgage. But if it goes up, you're going to want to find out why. Okay? In number 4, this is showing you who the owner is right now. Who's the grantor? It's You'll Be Sorry and Wendy House and their husband and wife. You want to make sure, I can't tell you how many times I get a contract where the seller is just You'll Be Sorry. And then I look at this and I go, okay, who's Wendy House and why is she not on my contract? And that's when I pick up the phone and call the other side and find out what's going on. Because if I don't have Wendy House's signature on my contract, we may have a problem. And sometimes people separate. One of the spouses decides to sell and not tell the other spouse, or any number of other issues. But this is an indicator, if this doesn't match your contract, to start asking why. Okay? Any questions here in Schedule A before I go on? Yeah, go ahead, Scott.
Yeah, I just have a quick question about what you said. Let's just say husband bought the house, they're happily married, they're living in it together, everything's fine, and that the wife will, like, the husband just appeared on the contract without the wife, and everything's fine. She'll show up to settlement. Is that still a problem with the contract?
Yes. So let's suppose husband bought the house.
Did you get all that? My internet connection's terrible.
I got you. Let's suppose husband bought the house in 2010 before he got married. Then he gets married and they've lived there as their primary residence. Wife needs to be on the contract on the deed. Wife enjoys what's called an equitable ownership interest by virtue of the fact that that's their marital home. And so she has an equitable ownership interest, a right to live there. So that right will stay until she extinguishes it by signing a deed and giving it to the purchaser. So if she's not on the contract, if you've got the buyer and you know that the seller's married and you only see You'll Be Sorry on here, again, it's an indicator to you that you need to pick up the phone and call the other side and say, hey, we need to add Wendy House to the contract, and she's got to be run through title as well, because they're going to need to do a search on her also. Okay?
I wanted to ask, I'm sorry to interrupt the group. I put it in chat. My documents came up sideways. Does anybody know how to rotate them? Did everybody else's come sideways?
Yeah, there's a button. Yeah, they did. There's a button on the top that, well, I use an Apple and it just says rotate. It's next to the edit top right.
Okay, yeah, I'm on a PC, not an Apple, but I'll try, thanks.
Okay. You could always turn your head sideways.
Okay.
Good morning. This is Tokumbo Ford. How are you?
Good.
I have a question. I just had something come up with an estate sale where the owner of the property on the property tax record was different from the seller.
The what was different? I'm sorry.
The owner of the property on the property tax record was different from the seller. Apparently, they had what they call a trust.
Okay.
So, so when I was preparing the contract, it was an up north thing. So I had to prepare the contract, even though I was the buyer's agent. So I looked at the property tax records, and then something was not right. So when I called the agent and I said, "Who is the seller?" Then she gave me another name. And so in cases like that, what should we be aware of as agents?
So you would need to amend the contract to make it the actual name of the seller, whether it's an estate, trust, whatever it is. It's if there's been a deed from an individual into a trust, the trust is the seller. Pardon me, if the seller was Mary Smith and she's now passed, the seller is the estate of Mary Smith by Sally Jones, her executor. That's who the seller is. Okay. So what it can't be is if Mary Smith was the original owner and she's either died or conveyed to a trust, Mary Smith can't be the seller.
Okay.
Okay.
All right. Thank you.
You got it. Okay. Anything else on Schedule A? Cool. All right. Well, let's move on to Schedule B1, which is 2 more pages past, page 3. So if you look at the top, this says Schedule B, Section 1, Requirements. This is your roadmap to closing. These are the requirements that the title agent needs to be met in order to be able to go to closing and have a deed pass and title insurance policy be issued to the buyer. This is very, very important. Okay. So you'll have standard requirements that are typically, you see 1 through 4. Those are standard. They're going to be in every commitment you see. Number 4, 1 through 3, I'm sorry. Number 4, if there's a mortgage, is going to show just like this, and it's going to say, we need, if you look in bold, production and record a deed from You'll Be Sorry and Wendy House by her attorney in fact, You'll Be Sorry, to John Doe and Mary Doe, husband and wife. So again, you need to look at this now. Does this match your contract? Okay. And you see here that they're saying that Wendy House is not going to be signing. You'll Be Sorry is going to be the signer for her. He has a power of attorney. And so we're going to talk a little more about the power of attorney later in this, but that's just an indicator for you, again, to make sure, this is what we call the deed call, okay? That the deed matches the contract. The deed that's required for closing matches the contract. Are all the parties here? And if there's names that you don't recognize, this is when we're picking up the phone. And you're going to make a mental note about the power of attorney. And then you also see that what is required is a mortgage from John Doe and Mary Doe, the purchasers, to their lender. Okay. And so when you look at this, you want to make sure that this, now this doesn't talk about an amount or anything like that, but it says they're going to give a mortgage. So if you have a cash deal and you open up this commitment and you see in Schedule A or here in Schedule B1 that there's a lender policy coming in, if you see that, then you know you got a problem. If they presented a cash deal and now there's a loan. The deal that I was just talking about in Ocean City was written up as a cash contract, a cash deal, and it wasn't a cash deal. The buyer needed a loan for $2.3 million. And when the seller got title the day before closing, they looked at it and said, what the heck is this? You never told us you were getting a mortgage. And there was a problem with the lender. And so that's something that you want to be very, very aware of as you look at this. Going down, the rest of this first page of Schedule B1 is very standard. These are standard requirements. But as you go to the next page of Schedule B1, if you look at number 10, it says, hey, we require a notice of settlement. A notice of settlement is filed no later than 60 days prior to closing, and it's a recorded instrument, and it's very important. And here's why. This is notice. So if somebody, let's suppose in this deal, the buyer's title agent sends out and records a notice of settlement that they're going to be purchasing this property. That's a recorded instrument at the county, just like a deed and a mortgage. If the seller goes and puts the property under contract with somebody else, when those people go run title, they're going to see a notice of settlement has been filed already on this property. And I've had this happen before, where you pick up the phone and you call the other side and say, why is there a notice of settlement outstanding right now on this property? Do you have another contract on this property? And sometimes the answer to that's going to be yes. I've actually had agents say to me, can't we do that? And so the answer, of course, is no. You can't have two contracts out at one time. And so this is a really, really important thing. If there is on your deal, if there is a notice of settlement that had been filed by a prior deal, a different deal, it's going to come up as a hit in your title search. But this is very, very important for you to be aware of, okay? Number 11 is telling us that the seller, You'll Be Sorry, and Wendy House, took out a mortgage with Absolute Home Mortgage. It was dated 2/26/15. It also shows us when it was recorded, and it shows us and where it was recorded, the book and page number, and it shows us the original amount. I always look at this. I look at this in public records at the beginning of a transaction when I represent a buyer, because I want to make sure in the beginning, and if you haven't done it in the beginning, definitely now when you get this, is there actually equity in the property? Sometimes you're going to see more than one mortgage here. Sometimes you're going to see, and this is oftentimes an issue with getting to closing on time. You may see this mortgage, and below it, you might see a mortgage that was taken out by a prior owner in 1973. And it's clearly been paid, but it hasn't been released from the property. If that's happened, that mortgage, the old one, we need proof that it's been satisfied and it's got to be released, or you can't close. Or let me rephrase that, you may not be able to close, depending on a variety of factors we won't talk about right now. The bottom line is that has to be dealt with. So you want to look here in number 11, you want to look and see, is there more than one mortgage? Do these add up to more than my sale price? And is there an old mortgage that hasn't been discharged yet? Very, very important. So as a buyer's agent, if you don't have an attorney on your deal, I get this frequently. I'll get an agent that will call me the day before or the day of closing and say, we just found out that there's 3 mortgages on this property. 2 of them are from 30 years ago. What do we do? And the answer is, we can't close today, probably, or tomorrow. And honestly, you didn't just find out, because when this is emailed to you, the title agent, YHT included, is not going to sort of take you by the hand and spoon feed this information to you. This is one of the reasons why we have Opinion 26. It says, hey, you should get an attorney. They're not going to say, hey, by the way, there's 3 mortgages, 2 of them are old. They're just going to say, here's the email to you and say, here's the commitment. As an agent, this is one of the places where you're going to say, all right, we definitely have an issue. I need to start asking some questions. You can call YHT or surety or whoever it is that's involved in the deal, who the title agent is, and ask them questions. But they're not going to do the work to get the old mortgages off the property. That's not going to happen. And they're not going to tell you at the beginning, here's your problems. They're just going to say to you, here's the commitment. So you want to be very, very aware of this issue. It's a fairly big issue. If you look at number 12, Superior Court judgment, and they list the judgment number, and it says see copy attached. They're telling you that one of the sellers has a judgment. In New Jersey, when somebody gets sued, it doesn't matter what the basis is. If they didn't pay their credit card bill, if they punched someone in the face, it doesn't matter. If somebody gets sued and a judgment is assessed against them, the judgment becomes what's called docketed. And when it's docketed, it becomes a lien against all real property that that person owns. So if Scott rear-ended me and I sued him and I got a judgment against him for $5,000, when I docket that, that becomes a lien on his real estate, all of his real estate in New Jersey. And so this is showing us that there's a judgment against the seller and it has to be paid and cleared off the title on or before closing. So when you see this, you need to look at it and see. So in this deal, we have, I think it was a $475,000 sale price. We know that they have a mortgage of $228,000 that was taken out a few years ago, so they probably still owe about that amount. And now they have a judgment. If this is a judgment that's $1 million, you are not closing. That deal is now underwater. So you need to look at this as soon as you see it, there's a judgment and go, okay, how much? And it will be attached to your commitment and you'll see the amount of it. You'll see the date. You'll see who sued the person, because now you need to go to that person that sued the seller and it's got to get worked out. That judgment that's now a lien has to be released from the property. I know that was a lot of information, so I'm going to stop here. Anybody have any questions about that piece? Okay. All right. So that's also very, very important. Okay. You also have in number 13, possible outstanding estate and interest in Susan B. Dollar by virtue of a life estate granted to her. So Susan, that means that at some point in time, Susan B. Dollar owned this property. She's probably a parent of You'll Be Sorry or Wendy House, where she owned the property. And they say, hey, Mom, we'll buy the house from you. You can have all the money, blah, 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 and we'll take care of everything, but you can live here until you die. That's called a life estate. And so she has an equitable ownership interest, just like a spouse would have. She can't sell the property herself and obtain the money because she's given up that right. But what she has is an equitable or possessory interest to live there. And so they're making you aware of that. She's going to need to sign off also on this. She's got to extinguish her interest in this property when this closing happens. Okay? All right. These don't come up a ton, but from time to time you see them, a life estate. Okay? In number 14, they're showing you that You'll Be Sorry and Wendy House also didn't pay their taxes, and the IRS has a lien on the property. And so now you want to look at this. This will also be, the amount will be attached to the commitment in the search. You want to look at this and see how much do they owe? Again, because the deal looked great to begin with. We're paying $475. They only had a mortgage of $228. It seems like they've got plenty of equity, but now we know that they got sued for something and there's a judgment, and we now have a tax lien, and we may have more than 1 year's worth of tax liens, whatever the case may be. So you have to start looking into how much do these people actually need to sell this property? What do we actually need? Okay. Just more information and more of why you need to look at this as soon as you possibly can. I'm always looking to, if I represent a buyer, number one, I want to know as many of the issues as I possibly can as early as I can. And number two, if we have a deal that really isn't a deal, I want to know that as soon as possible. Number one, for my client, so that they're not spending money on appraisals and inspections and all that stuff, if it's just going to be for nothing. And number two, if I'm on your side of this and I'm the agent, I don't want to be hanging out hoping that we're going to close. You know, we get through inspections, we get a mortgage commitment, and you guys are like, awesome, now we just got to go to closing and I'm going to get paid. And then you find out the day before that you've got a judgment, you've got tax liens, you've got a life estate, you got all these issues, and all of a sudden you're like, oh my God, we can't close. So you want to see this as soon as you possibly can. Again, the reason why you want to order this as soon as possible after you get out of attorney review. Okay. So I'm going to move on now. Any questions about any of this? These are, again, the B1 requirements. I'll get you in a second, Claudia. These are B1 requirements. This is your roadmap of what has to happen in order to go to closing. So when you guys go to closing, How many of you asked for marked up title at the end of the closing? Okay. So when you get this and you see an R with a line going down or an R next to each one of these, what they're doing is saying these requirements have been met. That's what marked up title is. Okay? So when you're asking for it, this is why you're asking for it. This is in case there's a problem and the title agent made a mistake. If they say, for example, that they took care of B-114, the federal tax lien, and they put an R, it's removed. If they do that and it wasn't, the title agent, whoever it was that did the deal, is going to be on the hook for that because they're saying it was removed and they gave good title and it wasn't. Okay? Claudia, you had a question about B1? Can't hear you. I don't read lips either. I'm sorry. All right, well, Claudia, if you get your sound on, we'll come back to you, okay? All right, so we're going to move on to Schedule B2. This is the exceptions. This is the title agency, and not the title agency, it's the title insurer saying, these are all exceptions to title. These are things we will not insure. So again, really, really important. The beginning of this, 1 through 7, these are all standard exceptions. They're going to be in every policy. If you go on to the next page, this is what I'm always looking, not always, I mean, I look at all of it obviously, but this is the end. Number 10 and 11 is something that I pay very close attention to. So let's suppose in number 10, it says, we're not going to insure the easement that's in book 1455 at page 523. So if anybody doesn't know what an easement is someone else's right to use the land as if they own it. Okay. And so there are what I would refer to as like typical and common easements, like utility easements, gas company, electric company, cable. They typically have easements on the property that allow them to come on and dig and do whatever they have to do to provide services. That's very standard. What you might not typically see, though, is an easement that allows the next door neighbor to use the driveway as if it's their own. You may not be able to tell when you're looking at the property that the next door neighbor's driveway is actually on this property. And that's an issue because if something happens on that property, and somebody gets hurt, the people that own this property that we're doing they own it and they are responsible for it, and that's their liability. So if there's an easement, that easement would give the next door neighbor the right to use the driveway as if it's their own. You want to look at this. So when it says deed book 1455, page 523, I contact the title agency. Some of them will send this to me as a link, and I can click into it and see it right away and read it and review it. If I can't, if there isn't a link, I will contact the title agency and ask them to pull that for me. Claudia, are you there? You're creating a, thank you. I'll ask them to.
I think that was me with the feedback. I'm having a lot of technical problems.
Yeah. Okay, maybe just mute that because it's creating a horrible echo. In any event, I will pull the easement and review it and then talk to my client and share it with them and say, hey, here's the easement. Are you aware of this and are you okay with this? So the mere fact that there's an easement doesn't give somebody the right to cancel the contract, a buyer. So for example, I'll typically build into my buyer's addendum that outside of typical utility easements, the buyer has to review and approve of easements, restrictions, things of that nature. So because there's no way to know until we get the title search what's actually affecting the property. And so that's 10. 11 is a setback. So it shows you there's a 40-foot setback. What that means is there's 40 feet of land that you can't do anything to. It might be a front setback, it might be a rear setback, this doesn't tell us. But let's say it's a rear setback of 40 feet. That means the last 40 feet moving from the front to the back, or from the rear edge of the property up toward the house by 40 feet, you can't do anything with that property. You can't build, you can't install, you can't do anything with it. You can obviously use it, that's not a problem, but you can't build any structures on it. You likely can't put a fence on it or anything like that. And so you want to be aware of that. I've had transactions where when I get this, I say to my client, hey, did you know that there's a 40-foot setback and there's an issue on the side and so forth? And they say, no. And guess what? We were planning to put in a pool and a cabana house and all these things. And now we can't. This property doesn't work for us anymore. And so you don't want to be in a position where you get a phone call 6 months after you close when your buyer calls you and says, hey, Claudia, why didn't you tell us that there was an easement going through the middle of the backyard? Why didn't you tell us that there was a setback? Backyard's beautiful, but we can't do anything to it. So you don't want to be in that position. I've seen where brokerages have been sued for that. And so you don't want to find yourself in that position. I'm not necessarily saying that it's a case that has legs, but you don't want to find yourself in the position where you're being accused of any of that, of not telling somebody. And so this is really important. We're going to see here, typically you're going to see if there's a wetlands issue, you're going to see it here. I recommend 10 times out of 10 to my clients that are buying that they get a survey of the property. We use that in conjunction with this part of the title section to see a full picture of what's going on this land. And if there's wetlands, typically that's going to be drawn in on the easement of where it is. Again, if I'm looking to put a pool in or build an outbuilding and there's wetlands on the property, it's not going to happen. And so the survey is going to show us that in a one-dimensional drawing, and we have Schedule B2 exceptions that we're going to match up to that. And so even though a survey is really not a lender requirement anymore, which is something that still sort of boggles the mind, it is something that I strongly encourage my clients to get. It's not mandatory, but I can tell you right now, I have a matter that's going to go into litigation in Mount Laurel where somebody bought a house and there was a pool, beautiful pool in the backyard, and they backed up to woods. And it turns out they didn't get a survey when they purchased. Nobody knew how to read this. They didn't have an attorney in the transaction. No lay people know how to read this. They didn't know how to read this. Their realtor didn't know how to read this. They purchased, and it was in the title search. The swimming pool is actually built on township property. It's township land behind their house. And that tells us that when the pool was built, there were no permits because there's no way they would have gotten a permit to build on township property. And now the township has come to them and said, you got to move the pool. Pool's been there for 15 years. And the township came to them and said, we just discovered this. Your pool's encroaching our land. You got to get your pool off our land. And it's going to be a pretty serious issue because you can't exactly just pick up a swimming pool and move it. And so if they had obtained a survey, they would have seen that before they bought. So I tell my clients all the time who are purchasers, you get one bite at the apple before you're the owner. Spend $400 or $500 to get a survey. And if there's a problem, we deal with it before it's your problem. And so to me, although, I've all the time, agents, lenders in particularly will we'll be sharing a client together. They'll tell them, I can save you money. You don't need a survey. And I'm telling them the exact opposite. Don't be penny wise and pound foolish because you really can have a problem. I've had a number of cases that we've had that if the people had just gotten a survey in the beginning, they wouldn't have had a really significant issue that they're now dealing with. So that's a really, really critical piece. And so with that, that's really sort of the primer on title. And so we talked about Schedule A, which is who are the parties, how much are we dealing with, and the purchase price and the loan. Schedule B1, which is the requirements that have to be met in order to be able to get to closing, or what I call the roadmap to closing. And then Schedule B2, which are the exceptions, things that a buyer is not going to have insurance for once they've purchased the property. All right, so anybody have any questions about any of that? Awesome. You guys are all title experts. Nobody? All right. Okay. I've got a couple minutes left. If anybody has any questions about anything in general, I'd be happy to field them. I've got probably about 10 minutes left before I have to run. Nobody? Okay. All right, guys. Thank you for the time. I hope that this was helpful.
Can I connect with you about that? Can I connect with you with that Lake Pine thing? I got cut off.
Yeah,
before.
sure. Absolutely. Yeah, you can reach
Okay.
out to me if you want. I mean, we can talk about it
Thank
now.
you. Thanks.
You're welcome. Thank you, Tacumba. Scott, I think you're getting cut off again. If you want, just reach out to me in the office and we can schedule a time to chat about it.
Oh, can you hear me all right now?
In and out.
In and out. Okay. What's your number?
856-235-8300. I won't have time now. Unfortunately, I've got to leave the office in a couple minutes. But I'll be happy to, we can get a call on the books. I'll be happy to talk to you about it either later today or, tomorrow or what have you.
Ben, I finally
Okay.
got
Can you?
I can ask now if I can.
Yeah, Claudia, hang on 1 second. I think Scott was just finishing asking
Okay.
something. Look, Scott?
No, go ahead. Go ahead, Claudia.
All right, great. Go ahead, Claudia.
Okay, so been trying to ask since early in the meeting, when you were pointing out the things like even clearing up the old mortgages, that was like one of the first things, that didn't even apply to the current owner who was selling.
Right.
So I gather that obviously, the need for an attorney is there, but when you have a client who declines to get an attorney, are there any of these things that can be cleared up without an attorney, and how?
Hard to answer that in general terms. I mean, you don't.
Well,
have-
like the old mortgages, let's say.
Yeah, sure. It can be cleared without an attorney. Of course it can. I mean, there's very few things that you must have an attorney for. It's a question of, do you, your client, so forth, know how to do it? If you do, then fantastic. Then there's no need to get an attorney. But outside of that, yeah, I mean, you can. My recommendation to you as an agent is that you not get involved. If you're representing a seller, you not get involved in trying to clear old mortgages for predecessors and title. It's way outside of the scope of what your duties are. And I understand there's people that refuse to retain an attorney, but in my opinion, as an attorney, not because I'm saying I want you to send me the business, I'm saying to you for your own good, your answer should be, I'm not qualified to do this, because to be very candid with you, you're not. I don't mean you.
Okay,
I mean agents in general.
right,
That's way beyond purchase and sale of real estate.
right. So you tell them this needs to be done. I can't help you with it. An attorney is your best bet. It's up to you if you don't want to get one, but
Yeah, I mean,
it
I
needs to
think.
get done. Okay,
Yeah, and I mean, if you have seller side processing through a title agency, they may help with that. It depends on what title agent and how busy and blah, 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 but they may be able to help with that.
thank you.
Yeah, sure. Anybody else?
You know what, Ben?
Yeah.
I had a leftover question from before. I think I had sent it to you. So it's not about today's lesson, but since everybody was quiet, that's why I'm asking. And that was when you have a seller and the seller goes into agreement with somebody, and then they see the home inspection and they back out. So then they put it back on the market and somebody else, do you have to show the old home inspections?
You don't have to show the report. You have to disclose the defects. You have to disclose known defects. The report itself, you don't have to disclose. It's always been my recommendation that you do, so there's no room for error by somebody saying, you never told me. But it's not required to show. That's a fallacy that you have to turn over the report. You have to provide the information. You don't have to turn over the report.
So if you have somebody that doesn't want to do a disclosure, which they don't have to do, so
Correct.
then how do they disclose the defects from the home inspection report? If they don't have to do a disclosure,
They must disclose all known defects, even if they've been cured in the opinion of the seller. So even if they don't fill out the form called seller's property condition disclosure statement, it doesn't absolve them. That's optional. The document is optional. The duty to report is not. So it would have to be in some other capacity. So it could be, in an email to you that you give to the other side. They could write up something in Microsoft Word and you give it to them. It could be in any capacity. It should be, in my opinion, in writing, so that there can't be a question as to what the seller provided. And so, there are times when Home Inspector X goes through the house and everybody thinks that Home Inspector X is a deal killer. And Home Inspector X does a report, he spooks the buyer, the deal falls apart, and now you're sitting with 150 pages of mush that you don't want to give to the other side because you don't even agree with it as a homeowner.
that's exactly my situation. Yes.
So what I recommend to clients in that scenario is that they go get their own home inspection. I actually recommend to sellers that they do a home inspection before they list the property and make that available to all potential buyers. So if that hadn't been done, very few people do it. Although I think it's a great strategic move to do it before you list and provide it. But now, if you have the terrible home inspection report, my recommendation would be that you get a rebuttal report. You go get another home inspector to come in, and now you say to all potential future buyers, here's home inspection X. We don't agree with it at all. We brought in home inspector Y. Here's his report. Here's both. Do whatever you want. Here's all the information. And so I think if you've done that, you give your seller tremendous credibility to potential buyers, and you hopefully have diffused whatever nightmare Home Inspector X created for you. And that's.
Thank you.
Yep. Scott, you had a question?
Yeah, I just figured, can you hear me good now?
Perfect.
I switched to my phone. That's what the problem was. And I figured you finished answering my question and I lost the connection. But it sounds like what they have to do is review I sent the woman who was asking, I sent her a copy of all the blocks and lots of the actual Lake Pine Colony Club owned property. So if there's the deed restrictions would have to be on there to govern the whole community or the whole lake itself, right?
If there are restrictions that affect everybody, they'll be recorded against every property that surround Lake Pine.
Okay.
If they're universal to all landowners that touch the lake, then they'll be on every single owner's land. They'll be
Okay.
recorded.
All right. So just to follow up.
What's that?
So just to follow up to that, my sister and brother-in-law last week, they closed on a property on the lake. So I just reached out to the title guy when this neighbor called me yesterday, and I had him review it, like look even more, and there weren't any deed restrictions at all that he could find. So based on that information, it's pretty safe to say that there's not these crazy deed restrictions on everyone's lots.
Yes, unless the searcher that their title agent used missed it.
Didn't go back far enough or something like that.
Whatever, yeah, just whatever, if you just missed it.
Okay. So the county deed books would have that if this woman wants to start going to the county and pulling as much information as they have archived on deeds, she could do that?
Yeah. I mean, that's what the searchers do. They actually go to the courthouse and pull them.
Okay.
So
So if, let's just say she discovers something, it doesn't sound like it, but let's just say that there is some kind of deed restriction on the property, would someone like you, is that what you do? Would you handle that? Like be able to get to, like, I guess if the HOA, or not the HOA, but the PUD, I was told that an attorney can, I don't want to say just get it removed no matter what, but if there's something on there that's conflicting, would you be involved in something like that?
So I'm not sure what you're asking me. I want to try to answer your question, but I'm not sure I'm following. So
let's just say it says you can't have motors on the lake, but we allow battery powered motors, just not gasoline.
okay.
So let's say she finds that deed restriction, because that's what one of the things that she mentioned specifically. Let's just say she finds that is actually on this, on the property, on one of the lots that is actually the lake owned by Lake Pine Colony Club. Can Lake Pine Colony Club do anything to change any of that?
So Lake Pine, the association, or whatever we're going to call it, who created the restriction, they can modify their restrictions. That can happen. But your sister and brother-in-law, if that restriction was missed in their title search, they have a title claim potentially, but it wouldn't allow them. So for example, if Lake Pine has a rule that's a restriction that's been recorded that says no gas powered motorcraft on water, and somehow that doesn't appear in your sister's title report, that doesn't mean that they're allowed to use gas powered watercraft. What that means is their title agent missed it somehow, their searcher missed it, and they potentially have a title claim, but it wouldn't give them the right to flout that restriction.
Okay.
Did I answer your question?
Yeah, and she named them, and I didn't really see specifics in writing, but she felt that, like, she was worried that, like, that if enough homes on the lake have these deed restrictions, that now Lake Pine Colony Club can use that to govern the rest of the homes that don't have them.
Well, I would tend to think that something like what you're talking about would not be on a lot by lot basis. It makes no sense. The lake
Right.
is the lake. So something that it wouldn't make sense that like a handful of lots would have that restriction and the others would not. And so I tend to think, take a look in Schedule B2 of their, did you do their deal? Do you have the policy?
It was private, so I helped them, but I wasn't paid, and it, but
Well,
I can get a copy of it.
Yeah, I mean, if you can get a copy of the policy, you can send it to me. I'll take a peek at it. But my guess is that there's probably a restriction in Schedule B2. Or if there isn't a restriction, somewhere there talks about in the policy, the covenants, conditions, and restrictions of Lake Pine, whatever the full name is, of that, saying that it's subject to the covenants, conditions, and restrictions of record. And chances are it probably is in their title search, but they didn't realize it, would be my guess. But I'll be happy to take a look at it.
Okay.
So Ben, I'm curious too. What's the practical implications? What does that mean when you have a title claim? In this case, for example.
It really is going to depend. I mean, I'm not sure what the remedy is if I bought a lakefront property knowing that I wanted to put, my yacht out there. And now all I can have is a canoe. I'm not really sure what the remedy is. Potentially, I could say, I don't want this home anymore. And I could file a title claim to buy me out so I can go buy somewhere where I can. It's hard, aside from that, from rescission and unwinding the transaction, it's hard to really, off the top of my head, think of a remedy that could be fashioned there, because money doesn't cure it. You wouldn't even know how to arrive at money damages for something like that. Whereas, if, for example, when they did the legal description, if they cut off, hey, Claudia, can you you're making me a little dizzy. I'm sorry. If you could just keep it still, that would be great, because it's swallowing up my entire screen. Thank you. If, for example, the problem is 20% of my land is gone as a result of a mistake they made, where I thought I had 100 feet, but I only have 80. And let's just say somehow the title agent missed that. We could find a way to monetize that, right? Because we can figure out what that land is worth and what I paid and what I should have paid and all that kind of thing. So it really depends. Claudia, please. Thank you. It really depends. Hey, Claudia, can you please stop shaking your monitor? It's taking up my whole screen. Please?
Yeah, it's my iPad. I'm trying not
Okay.
to.
Could you just make it flat? It's really hard for me to concentrate with that.
Okay.
Thank
And
you.
hit mute.
Yeah, that'd be awesome. Thank you. So depending on what the title claim is, there's many different types of claims. They all have to be fashioned one at a time, depending on what the issues are. There are a number, thank you. There are a number of different issues that could come up. So you really have to take them one by one. There is no universal cure for a title claim. It really is going to depend on what the issue is. So I don't remember who asked that, but whoever it was, I hope I answered your question.
Yep, thanks.
Awesome. Okay, thanks, Scott. Okay, all right, guys, with that, I actually have a hard stop at 11, so I need to run. Thanks for the time, and any questions, please feel free to contact me anytime. You should all have my email. If you don't, Jamie can certainly give it to you.
Thank you.
Thank you. All right, guys.
Thank you.
Thank you.
Thanks a lot.